Legally Brief is the first in a series of 3 videos produced in the wake of a decision by authors and publishers associations and approved by a federal judge to cancel a hearing regarding the settlement of a class action lawsuit these plaintiffs filed against Google alleging copyright violations. In this first video, Brian Anderson, a class action specialist and partner with the law firm O'Melveny & Myers, will assess what this development means for the settlement and what the next steps in the process could be.
The adjournment of the fairness hearing and the renegotiation of the settlement to accommodate DOJ concerns is a major setback for the parties and those who support the Google book settlement. Criticisms of class action settlements are inevitable. They're the result of compromise, which means nobody gets everything they want. But the parties who negotiate such settlements and present them for court approval bank on the doctrine that they are presumed fair. Judges prefer to approve class settlements because they take messy lawsuits off their docket. Judges also tend to defer to the compromises the parties made to achieve a settlement, and so tend to approve settlements even if they involve rough justice. Here, by agreeing to renegotiate those aspects of the settlement that concern the Justice Department, the parties have lost that aura of inevitability. They have implicitly admitted that their original proposal would not have been approved. This makes it harder for them to argue that any revised settlement they come up with should be presumed fair. Reopening the settlement to address the DOJ's concerns also will embolden other objectors to press the parties to address their concerns as well. The settling parties will have to make hard decisions about which criticisms to accommodate and which to ignore. Changing a complicated settlement like this isn't easy. All the pieces of this settlement fit together like a machine. And changing one part of the machine requires changing other parts to make the whole thing work and to reflect the overall compromise reached by the parties. In short, having opened Pandora's box a crack to make a few tweaks, the parties may find themselves having to open it wider. There is a risk that they will never be able to close Pandora's box again. Stopping the current settlement approval process also raises procedural questions about how the approval process for any revised settlement will work. The parties' previous notice program has been criticized, and they will surely be pressured to disseminate a new notice, including a more robust mailed notice program to all class members. Class members presumably will have a new opportunity to opt out of the proposed class and a new opportunity to comment on the revised settlement. So the delay here will be measured in months, not weeks. But all is not lost for the parties to the Google settlement. Some objectors argue that this settlement is fundamentally a misuse of the class action device. They broadly attack its core strategy of using a class action final judgment to change class members' substantive legal rights, arguably a violation of the Rules Enabling Act. But DOJ's statement of interest went out of its way to note that the settlement offers an important public benefit. They like the idea of making all books ever published more readily available to the public. DOJ hinted that it might support a revised settlement if the class definition is narrowed, if new class representatives are added, and if Google's competitors are allowed access to the digitized materials. Likewise, Judge Chin's recent order notes that the proposed settlement would offer many benefits to society and suggests that renewed negotiating will alleviate what he called fair concerns about its terms. The parties presumably will report on their progress and their plans at the October 7 status conference. So we should know soon whether or not the settlement is viable. Whatever happens, we do know this: the story won't end soon. The Google book settlement is one of the most ambitious uses of the class action device to solve a public policy problem ever attempted. It shares some of the controversial characteristics of the asbestos and Agent Orange settlements, both of which were ultimately disallowed. Even if the parties revise the settlement, and even if Judge Chin approves it, someone will appeal to the Second Circuit and thereafter the U.S. Supreme Court. It will be an interesting process to watch.